do you pay a debt for someone you owe 36 million? You don't. It might as well be a gajillion.
Hello, everybody.
Oh, this is what you do. You charge the one you owe with murder. The debt goes to. Now first, you gotta have a body. I don't know how you get it, but I know it is nutty. Find that car that body drove. Park the car in the yard. Throw the body in the stove.
Hello, everybody. Hello.
Now this part, overemphasize I can. You got to have law enforcement that likes to plan.
Oh, I mean, not botany.
Talking bones, blood, bullets, a car and a key. How do you pay a bill for someone you owe 36 million? You don't. It might as well be a gajillion. Oh, this is what you do. You charge the one you owe with murder. The debt goes to. Now you cook that body up, all well done. Just leave some pieces out
For identification.
Like the tibia, piece at
23. Oh, wait. Some of you ain't following me.
But this brings me to the important part of the scheme. You got to own the lab and forensics team. Pick one out, the dullest knife. Get her to deviate from protocol first time in her life. How do you pay a bill for someone you owe 36 million? You don't. It might as well be a gajillion. Oh, this is what you do. You charge the one you owe with murder. The debt goes to. Now I can't go into detail. It would take
Too long.
This would end up
Being a 10-part docu-song.
So I'll just give it to you. Form. Do all these things and you can toot your horn. You first have to get a kid to confess to the story you feed them. Block all the officers from following evidence where it leads them. Tell the media things that don't make sense. Don't worry, they don't ask questions. They just nod their heads. You gotta lock the corner from the scene. You got to beware now, dogs that are mean. Lose all the cameras,
Don't take a shot.
Multi-label everything you got. You gotta keep all the evidence locked up safe. If anything gets broken, fix it with scotch tape. Then repeat. The phones are intertwined. The wires from the ties.
Oh, you think I need the song text? You actually think, Roll, I don't need the lyrics written down for me.
Oh, this is what you do. You charge the one you owe with murder. The debt goes to. Now say you get away with all this stuff, but 10 years later you just don't have enough. Go write a book, try to cash in, don't worry about the ethics.
There's none in Wisconsin.
Cause if there are, you would have been jailed and sued from all the domestic violence victims that you abuse. How do you pay your bill for someone you owe 36 million? You don't, it might as well be a gazillion. Oh, this is what you did. You raped an innocent man
And his nephew kid. I love it. It's like I've said before, man, you can tell how much time Dassey has spent in the documents when you listen to his songs. Hello, everybody. Hello. We're in the Charlie Barron's Wisconsin t-shirt tonight. Instead of, Wisconsin flag usually says forward, but because this is Charlie Barron's, it says keep her moving. So keep her moving. Anyway, those of you who know Charlie Barron's. But anyways, so he recreated the state flag, obviously. Didn't used to have a chick with a barbecue, or it didn't look like a tailgate party before, but Charlie made it look like a tailgate party. So anyway. All right. So how you doing, Travis?
I'm great. Happy Friday.
Happy Friday, everybody. Yay, it's Friday, right? How many people are having cocktails?
Not yet. I will though.
I'm waiting for the I'm waiting for the people in the chat to start telling me. I know there's gonna be wine, and wine. No. Travis is invisible. That's true. Hold on. Now he won't be invisible. Ah, Coca-Cola. Wow. Coffee.
Oh, you got your Dr. Pepper going?
I got my Dr. Pepper. Although I wish I had a beer. I might go get some beer after this.
Hey, you have any of your Wisconsin natives subscribers on tonight? Any of your Wisconsin folks? Anybody from Wisconsin on there?
Let's see. Anybody that I would recognize as. Mark Havey is from Wisconsin.
Great, Mark. We're going to be asking you later, and anyone else from Wisconsin, to, what you can tell us just in general about Eau Claire County. And I don't know, you may know these two small towns, but if you do, great. But if you just know about the county, when we get to it, we'll ask you to tell us what these places are like. Village of Wheeler, Wisconsin. Village of Wheeler, and Village of Boyceville. And my understanding, those are both in Eau Claire County.
Eau Claire County. Okay. Well, Juan Tesker has joined us, so he might be able to help out with that.
Okay.
See, I haven't seen Ziggy all day. Ziggy will be here, I hope, soon. Let's see. Did you know all Wisconsin people live in a state of emergency? What the hell? What are you talking about, Roll? Anyways. Okay. So we're here today, folks, to talk a little bit about this recent decision in Wisconsin handed down by the Wisconsin Supreme Court that is essentially going to redefine the interpretation of Brady and shift it back, to what Brady was meant to do. To put it, quickly, it's basically going to shift the focus back to prosecutorial misconduct and take it away from having it all be about defense's due diligence, which is what Brady has become. It's essentially become this thing where they just walk into court and argue that the defense could have possibly gotten this if they did this and that and whatever, basically where they make the arguments that the defense could have possibly found this, justifying their hiding it, which I don't feel it does. What they're saying now is they're saying that that's not going to be the case, that it's going to essentially be, if the prosecution has it and it's helpful and they choose to sit on it, that act in and of itself is against, essentially the principles of American jurisprudence, or due process. Eau Claire is about 100,000 people. Let's see, it's about the same size city as Green Bay.
Okay.
Otherwise, he knows very little about it.
Okay. No one's heard of these little villages. I guess those are small towns.
Yeah.
They're smaller than a city. They're, I guess they're what we call a town out here or in California. Wheeler. No one's ever heard of that. Wheeler.
Yeah, I don't see that one yet. Jojo Mary. We'll get to talking about whether or not it's, I think you meant retroactive instead of retrospective. I don't even know if it's retroactive right now, but it doesn't need to be as far as I'm concerned, but we'll address that later, hopefully here. So, but just for everybody to realize.
Making a note right now. Talk about retroactive. So we will answer that. Yeah.
Right. Okay. So, but right now I tell you this, we don't need it to be retroactive because all of KZ and Stevens issues are pending currently in the appeals court. So that means that this will apply to that. Even though it was decided on by Judge Angela last year, the year before, whatever, all that stuff, but it's still in the courts. It's in the appeals court, and the appeals court can apply this new standard. So, not sure why you're asking why you're asking whether it's retroactive, but as Travis said, we'll get to that later.
Because maybe she is thinking about Brendan's case, which isn't pending. So that's why we're going to take the time to fully explain that and answer.
Sure. Okay. There you go. Let's see. That's the entire county that is about the population of the city of Green Bay. I know Wheeler has something that happened with it within the last few years, but I can't remember what. Pipe explosion or something.
It's this case here also. It's what happened up in Wheeler and Boyceville. Pipe explosion. Dang. Woo. Sounds like Oklahoma, Texas. Pipe explosion. Wow.
Oh, there's Ziggy. Ziggy's with us. Okay, so I think Nyright and Dridgen can file a new appeal, and then Brady would apply.
No, we'll get to that.
We'll get to that roll. I didn't mean to worry you, but remember you have my phone number. Oh, remember some of you have my. Okay. Let's see. Or a tornado, something. Oh, he's saying there might have been a tornado there recently, I guess. Can this help? Brendan, we're going to get to that, Christina. Travis, we're going to be getting to that. So he's going to cover that. Let's see here. Excellent point. Let's see. Why is there nothing current for BD? Pipe bomb, tornado, it's all the same.
I guess so.
All in a day's work in Wisconsin. Anyway. Boyceville is ask Mark Havey where he's from. Mark Havey, where are you from? Just outside of Green Bay. Okay, so we have I guess we'll just go ahead and start in here. I know Travis has some things to put up on the screen at some point, but basically on the 7th of February, the Wisconsin Supreme Court made a decision in this case, Wayerski, and although it didn't ultimately pan out for Wayerski the way I if I understand that correctly, right? He ultimately didn't win, but he was able to make his challenges, right? Is that what happened, Trav? Uh-oh. I think I lost Trav. Trav's been having a problem with his computer. Wayerski is a guy who who was brought up on charges. There he is. There he is. So anyways, what was I saying? I was just asking you something, but you were frozen. Anyway, so this decision came down on the 7th, and I guess, this guy was brought up on charges of was it molesting a 16-year-old?
Yeah, well, two 16-year-olds.
Two 16-year-olds?
So, yeah, let me just go through it real briefly, a couple minutes.
Go ahead.
July 2011, the state filed a criminal complaint against Wayerski. Ended up being 16 felony counts. The allegations against him are summarized as follows. February 2011, Wayerski, who was police chief
Mm-hmm.
of the village of Wheeler, and a part-time police officer for the village of Boyceville, offered to act as a, quote, mentor, unquote, to 16-year-old JP. That's obviously a pseudonym. When you have minors, you don't put their real names in the decisions. You always see it as initials, but he was going to mentor JP. And then in March of 2011, Wayerski issued 17-year-old JH a disorderly conduct ticket. And then he said, yeah, if you go on ride-alongs with me and other stuff, you'll be able to get this dismissed. There won't be any record of it. So, used his position of power to sexually molest 16, 17-year-old. I went to trial and lost. The two boys, 16 and 17, testified against him. They were the primary witnesses. Wayerski made a general defense that the boys were fabricating the allegations because Wayerski was part of a drug investigation involving people that were connected with JP and JH. In rebuttal, the state called a gentleman by last name Clark, who was an inmate who occupied a jail cell with Wayerski, and guess what? Ended up testifying that Wayerski had admitted to many of the things that the juveniles were alleging occurred with regard to molestation. The opinion, and we can get a link for anybody that wants it if they want to read through the whole 65 pages. It goes into much more detail about the nature of the molestation, and just really don't want to get into all of that. Suffice it to say, the chief of police of the village of Wheeler and part-time police officer in Boyceville is not a very good individual.
Right.
I think on top of it, he also caught him with child pornography. But so on appeal, one of the big issues was that this Mr. Clark, the jailhouse snitch, had multiple pending charges against him, and the state did not disclose that to the defendant. So up at the Court of Appeals, they said, no, we're denying your appeal because it wasn't in the information, the potentially exculpatory information, the criminal record, or pending criminal charges were not in the exclusive possession of the state. In other words, they could have gone down to the courthouse, pulled up Mr. Clark's name, run it, saw if he had any pending charges.
Mhm.
The fact that he was in jail should have told the defense attorney that there were pending charges, but we won't. I don't. Doesn't say anything too much about the opinion on that, but it's pretty obvious he's got some sort of pending charges. But anyway, that was the argument.
Right.
So then they lost at the Court of Appeals. And then the next thing that happened was in Wisconsin, like a lot of states, including Texas, is they filed a petition for discretionary review with the Wisconsin Supreme Court. So the Supreme Court of Wisconsin, it's in their discretion, kind of like the U.S. Supreme Court, whether they're going to hear a case or not. And they granted a petition to hear the case, so they were going to hear the appeal. They also, Tracy indicated in Wisconsin, it's very rare that they grant oral argument in criminal cases, either at the Court of Appeals level or the Wisconsin Supreme Court level.
Right.
This case, they did grant oral argument in September of 2018, September 5th. And then, of course, the case, the opinion was filed. The case was decided February 7th. So what is that? 5 months. Took 5 months to issue a decision.
Right.
We're trying to give some more time frames when we have them, even if it's an unrelated case, just so people can start, kind of having a time scale. Is 5 days a long time for a decision after oral argument? Is 5 weeks? Now we have one case where it was 5 months, so that gives us some idea. And I'll also be able to pull up the dates, and we'll go through those another time on when it was in the Court of Appeals, how long it took between the time everything was submitted and they got a decision. So, why is this important? So, and this came out on a blog, which I subscribed to, and was also posted immediately by somebody on Twitter. It's called the Evidence Professor blog, and he's a law professor at the University of South Carolina. Actually where I first learned of him, Erekose, is through you in a roundabout way. Do you know why or how?
Let's see. Probably somebody I know.
I'll give you a hint. Texas Tech.
Oh, from the Texas Tech videos I put up.
So I don't know if you recall, but one of the professors there talked about where all of this initially after MAM1, which came out in December of 15, correct? December 2015?
December, okay.
Is that right?
Which,
Number one.
yeah, it was right. Yeah, near the end of it. Near the end, I think. It was December, yeah.
Okay.
No, wait. No. Those were at the
No.
beginning of December, end of November when I was posting those.
No. When did Making a Murderer 1?
Oh, I'm sorry. Yeah, December 2015.
Thank you. Okay.
Sorry, go ahead.
No, it's all right. I'd just like to confirm the dates with you because,
Yeah.
You or Allie are the ones I go to for a lot of this stuff, or Julie, or because, there's just so much. Anyway,
right,
so
yes.
He did a presentation that you did on your channel. You replayed it. He did a presentation that within a week after Making a Murderer hit, that there were 7 things that Making a Murderer didn't tell you, or 10 things that Making a Murderer left out. Okay. And this professor tracked, the professor did the presentation at Texas Tech, showed the professor, the Evidence Professor blog, he had tracked this stuff, whether it was 7 or 10 or whatever. He tracked it all the way back to an email that Guess Who had sent out to a couple of media outlets about 7 things that making a murderer left out.
Right.
Email by Kratz.
Mm-hmm.
And then it just kept getting repeated over and over and over again. And then they would add to it, but it was essentially the same stuff. And I highly recommend, if you haven't seen that video that Erekose did about it, you just put in Erekose and Texas Tech. It'll get it to you. He broke up all of the videos.
There's 4 of them.
Segment, and
there's a 5th one because there's like a conclusion, I think. So
this I think was about the 3rd or the 4th, but it's really easy to tell what part of it is. But anyway, so that's how I knew about this professor. So he did this article that talked about. He did an article on the 13th, day before yesterday. And then right in the midst of, all this stuff going on with Zellner and her filings and whatnot. And then he's talking about the case. Now, he did a 2 or 3 page article that summarizes the case. The case is, this is 15 double-sided pages. And then there were a couple of dissents.
Mm-hmm.
And that's another 55 pages. But anyway, we're not going to go through all of that. We're just
By the way, just want to say real quick, thank you, Steve Watts. Thank you very much. It's very kind, very generous. Thank you very much. So sorry, go ahead, Trav.
Interrupt me anytime something like that happens. I have the screen up of a PDF with my notes and the decisions, so I can go through this quickly.
Absolutely.
But I'm assuming someone made a nice gesture your way. So interrupt me. I can't see the screen at all for the next 5 or 10 minutes. So
I'll wait for the best point to kind of try to cut in without,
just jump right in. Anytime you see one of those, man.
Sometimes. Sometimes people want to hear the end of your stream of consciousness there. So anyway.
No, you got to have the ducks in a row, baby.
The ducks in a row.
All right, so let's just go through this quickly. And then let's answer some questions. So what's significant about this case, even though they didn't reverse the conviction of this horrible human being, former chief Wayerski, and it looks like he's going to be locked up for a long time to come, and probably a good thing is they overruled a couple of cases, and that's why it's very significant. Anytime the Supreme Court overrules a case, that's a big thing. But let's see how how this may shift and be a big thing for Stephen, hopefully, and whether it might be something that Brendan can use as well. So what this case essentially did is, for Brady, you used to have to show, one, that they withheld information, the state withheld information. 2, that the information was material, it's important, would have resulted in either a probability that the jury would have found the defendant not guilty, or it could have been used by the defendant to impeach or show bias of the witness. And it had to be in the exclusive control of the state, exclusive control of the state. So those 3 things. Well,
right.
It shifted it. So they kept focusing on, well, is it in the exclusive possession of the state? And they kept looking at, well, did the defense attorney was it also available to the defense attorney if they had really done their homework, or if they'd used due diligence?
Mhm.
So the focus was they'd look at the defense attorney's conduct. So the way this evidence professor characterized it, and I don't think I can do any better, and why this is significant, says in Wayerski, the Supreme Court of Wisconsin held that Wisconsin courts had shifted the focus from the state's misconduct to the defense's due diligence and issued a course correction. Held that the courts in the past had shifted the focus from the state's misconduct to the defense's due diligence. So it's making a course correction back to the state's misconduct. We're not going to look at defense's due diligence anymore. That's a major shift. So they first talk about, that Brady was decided in 1963, thereabouts, and it just said you had to turn over all exculpatory material to the defense. It's like, where did this due diligence or exclusive possession come from? And in the opinion, and I'm not going to spend more than 20 seconds on this. That's odd. I picked that time frame. Anyway,
Right.
they explain where that came from, and where it came from is Justice Fortas, Abe Fortas, who was on the United States Supreme Court. Remember, Brady is a U.S. Supreme Court case.
Right.
Well, there was a follow-up case to that in a case called Giles v. Maryland, and he wrote a concurring opinion, and in it he said, this exclusive possession and control limitation is rooted in Justice Fortas's concurrence, where he stated, if the state has in its exclusive possession specific concrete evidence, which is not merely cumulative or embellishing and may exonerate the defendant or be of material importance, the state is obligated to bring to the attention of the court and the defense. So Fortas started this sentence with, if the state has in its exclusive possession, and so on. Well, then courts started picking up on that, and they started adding it to their requirements that it be material, and that it be in the exclusive possession of the prosecutors. It popped up. It was never in the original.
All right, I'm gonna stop you for just a second. I'm gonna do something I don't usually do, folks. Julie, I was holding off on doing this, but this is happening now. If Holly and anybody responding to Holly cannot keep their comments to themselves, delete the comments. Okay? I tried to keep control of it. I tried to be nice about it. After multiple nice times of trying to tell you, Holly, you couldn't, you pushed it. You pushed it to the point. Okay? So, you are now going to get deleted. Everything that you say that doesn't pertain to what we're talking about, and if the word Discord is mentioned, it's going to get deleted. Okay? I told you to bring this up with me later, not right now. Not at this time. Okay, that's all I have to say. Sorry, let's go ahead.
No, suit she does.
Well, anyways, that's enough. I've said what I had to say, and I'm done with that taking up time on this video. So
okay, let's see.
Pom Pom will take care of her. So
I'm trying to remember where we are.
Well, we were talking about You were talking about what was it you were talking about?
It doesn't really matter.
Well, here.
That what you were going to bring up, you had mentioned that you had heard from some people why a court would make a big change in their position or their holding, or why would they reverse a case. Before we started today, you said you'd heard from some people why, and I thought that would be good to share with your folks. Why courts do you don't remember? Okay, I'll fill in. I'll fill in while you're trying to remember.
I'm trying to remember exactly what I was saying at what point.
All right. Well, why you have a little shift or a little addition, why you add something like.
Okay.
Oh, you got it? Go ahead.
Okay. What I was talking about is that what's the important prong of Brady, folks, is proving bad faith. You have to essentially getting to ultimately have your Brady claim be successful. You have to prove that the state was like willfully hiding things from you and deliberately doing it. So when it comes to the CD and the computer evidence, it's obvious to me that the state was playing games and hiding things because they held on to it for 8 months. They held on to those DVDs and Fassbender's report, all that. Held on to that for 8 months and then literally started dumping it on Dean and Jerry about 3.5-4 weeks before Denny's due. I mean, you have to look at that. I mean, and that's going to be one of the cruxes of this case. And I hope that this new Brady interpretation here is going to help with this, because to have expected Dean and Jerry to go through the contents of an entire computer when they were already in that kind of final stretch, a lot of deadlines coming up, a lot of things they had to be ready for, and suddenly the entire contents of a computer hard drive are dumped in their lap, and they're supposed to like go look through that and everything. I mean, to me, it's somewhat unreasonable considering that the prosecution had it for 8 months and held back the CD that would have told Dean and Jerry that there was something there, that they did need to, look into it. Anything that would have made it obvious what was there was held back, held in Tom Fassbender's personal custody for 12 years. I mean, how odd is that? How very strange is that? But then we move on to this new evidence, right? The new thing here. The new Brady claim is with these bones. These bones, when she first filed, I was like, how well is this going to work? A missing, a couple pages in queso. Is that going to be enough? But then she files, but that was, somewhat significant. But we have that. So that's one thing, right? One thing that was clearly withheld and not turned over to Stevens appellate attorneys at the time. They were not asked before this evidence was given back. His Stevens appellate attorneys at the time were not asked, and then you have missing pages in queso for that were not given over to the appellate attorneys. Then she files another letter, and we're finding out that the evidence ledgers were not handed over to Stevens appellate attorneys either, because the appellate attorneys do not have the entry from 9/20/11 on it. So that's now 2 places. Then you have the second filing she just did recently, and now you have the phone call from the prosecution who thought he was calling Tom Fallon, and he's basically saying how we just need to put her off and avoid her, and we need to go look in that bag and see what's there. Nothing. The hip bone you're hoping is there isn't there, Mark. It's not. You guys gave it back. Yeah, your paperwork shows it in 2 different places. So to me, looking at the fact that they were doing that in 2 different places, combined with the phone call from Mark, Williams, that shows me kind of, well, as Juan would say, a pattern. Once is maybe like maybe a mistake. Twice is fishy. 3 times is a pattern. He was saying that earlier in the video when I was on with him, and when I was on Mr. Capaldi's video earlier today. I was on with Chad and Juan. Juan's in the in the live chat there, Travis. Anyway, he was saying that earlier that 3 times is a pattern. Let's see what we got here. Are you frozen up there, Travis? You still there? Okay,
No,
you're there.
can you hear me? I think I'm good. Are you all right? Can you hear me?
Yeah, I can hear you now. You were sitting so still that it was.
No, I was mesmerized like I normally am when I hear you talk. Just absolutely mesmerized. But no. So I got Caroline's question and Go Mean Green. They've got one. I got that. And we're going to get that. I'm just going to finish up with, why is this case important? And I'm not going to go through the history. If people want to know more about the history and the cases in Wisconsin, basically all you need to know is there was a case called Nelson that adopted this exclusive possession and control limitation of the Brady suppression. So to get Brady, basically Fortis added this limitation. You have to show it's in the exclusive possession and control. The defense attorney had to show that.
Right.
And the rules started out being, hey, this is what the prosecutor needs to turn over.
Right.
And so the majority of this court in Wayerski, they overruled that decision, and along with another one, but the Nelson case was the big one that they overruled. And they said this limitation of adding this exclusive possession and control component, this limitation further thwarts the purpose of the state's obligation under Brady to prevent the state from withholding favorable material evidence that helps shape a trial that bears heavily on the defendant and, quote, cast the prosecutor in a role of an architect of a proceeding that does not comport with the standards of justice, unquote. That's huge. That's a philosophical shift.
Right.
From, hey, you're his attorney, you could have gotten it, to
it basically is the difference between the court basically looking for any reason to be able to blame the defense for not finding it on their own, as opposed to what it is now going to be. Whereas if the prosecution has it, hand it over. That's what discovery is. Yep. Hello.
Yep. Good way of saying that.
Right.
We hereby overrule the holdings set forth in Nelson and its progeny. It's just a fancy lawyer word, judge word for subsequent cases, the cases that came after Nelson, that favorable material evidence is only suppressed under Brady where the withheld evidence is in the state's exclusive possession and control. They're clear that there are some federal courts require that the defendant show reasonable diligence. So they don't require exclusive possession. But they say, well, you at least have to show that you had some reasonable diligence.
Right.
Wisconsin Supreme Court says, no, we're not even going to do that.
Right.
The Wayerski majority is now saying, wait a second, Brady is about prosecutorial misconduct, not defense due diligence.
Right.
If the prosecution collects exculpatory evidence, of course it should turn it over to the defense, even if the defense also has access to that evidence and could discover it through due diligence. So that's it in a nutshell.
Right.
The majority, there were 3 judges who dissented. So majority opinion, it's the law of Wisconsin now, is now saying, wait a second, Brady is about prosecutorial misconduct, not defense due diligence.
Right.
If the prosecution collects exculpatory evidence, I think this bears repeating a second time, but I apologize.
No, go ahead.
Collects exculpatory evidence, Of course, it should turn it over to the defense, even if the defense also has access to that evidence and could discover it through due diligence.
So, yeah, so go ahead.
So, that's the thing. And then I think we'll talk a couple of minutes. How does it fit into Stephen's case? Can it be
Right.
used in Stephen's case? What about, is it retroactive?
Right. Which is what Amber Marie was asking kind of here to kick that off is, so with this new Brady interpretation, how much will this help Stephen get a new trial or have his conviction overturned? And for me, the answer to that question is this is going to finally make it possible for Stephen to get his evidentiary hearing, is what this is going to do. That's what this is going to pry that door open. Okay, essentially, hopefully. Where Judge Sukowicz has been slamming that door in Stephen's face and Kathleen's face, this ruling could turn that around. So to try to explain here, this is going to help Stephen with this claim that he's bringing right now, obviously, because it is a potential Brady claim. And so most likely he'll get, if this hearing really holds true, he'll get an evidentiary hearing on these bones being given back in violation of statute and all these sort of things, right? So
Yes.
yeah. So it's going to be that's what he's going to be able to use it there. So that may get him the evidentiary hearing on that, and that may lead to a new trial right there. If not, this evidence comes in, maybe it falls just short of them being able to say that there was bad faith. But I mean, there's a lot of shady stuff, but maybe the justices weren't willing to say it was bad faith, right? So then all this stuff comes back to the appeals court, and all this stuff then becomes subject to this new ruling. Anything that has to do with Brady in her original appeal and all this stuff will all be subject to this new ruling. And then it will be most likely a bunch of those will get evidentiary hearings, or, if this ruling holds, sound and holds, and is actually followed, then it looks good that Stephen will at least begin to find some success in my mind. Trav? So
let's, I like to analogize the current case, and I agree with what you're saying there. What this is going to do is hopefully allow her to it will apply to this case because his appeal is pending, and so when it ultimately gets to the point where she can file a brief on the Brady issues and all the other issues she's brought up in her motion for post-conviction relief, together with the supplements and the amendments and everything she's been doing, she'll be able to cite this new case in there. And the state, in response, cannot come in and say, oh, well, the computer records weren't in the exclusive possession of the state. They turned over the CD.
Right.
They turned over this.
Right.
And so it may not apply to all of her Brady issues, but the examiner with Q Discovery revealed multiple pictures of violent pornography, young deceased females, and Ms. Hallbach. The affidavit of Gary Hunt, expert opinion, a forensic examination of the Dassey computer. Mr. Hunt's forensic examination revealed pictures of the victim, multiple pictures of young deceased females. I guess that's one and the same person. That's Gary Hunt, and he's with Q Discovery LLC. Right. So they're not going to be able to argue that anymore. That we turned it over. We put it on the CD. You had to have a special program to look at it, but they're not going to have that defense any longer. So yes, this case does apply to Stephen's case. Now, cases like this are not retroactive unless it's specifically stated in the opinion that they're retroactive. It's not specifically stated in the opinion it's retroactive. So
Okay.
this would not apply to Brendan's case.
Anything in the past for Brendan, right?
Right. If he had brought a Brady claim and they denied it based on it wasn't an exclusive control, they said, no, we're denying your appeal. Of course, his appeal ultimately went into the federal system on something completely different than Brady. But
Right.
just as an example, this would not help Brendan in his case because his appeal, he doesn't have a pending appeal. Now,
Right.
if they somehow discovered a piece of evidence that wasn't disclosed to Brendan and he was able to bring a new motion, post-conviction motion, an 06 motion, and he was able to show why that wasn't discovered. Maybe it's because Kathleen finds something recently.
Mm-hmm. Mm-hmm.
Then he would be able to file that post-conviction motion, and he would be able to rely on the new evidence. They would not be the new decision. They would not be able to say, oh, well, if your attorneys had used due diligence, they would have found this. So it's a different situation for Brendan. But I'm almost positive this new case will be cited in Kathleen's brief that she files in the Court of Appeals. And that will occur after she has, hopefully, an evidentiary hearing. If Judge Angie finds that there was no violation of the statute or no Youngblood violation, it'll go back up to the Court of Appeals. But the important thing is that that issue will be consolidated with the Brady issues she's already saved. Now, one of the other questions that I've been getting asked a lot, including tonight, Caroline Spencer and Go Mean Green asked, I think Kathleen Zellner knew about this case. She absolutely knew about this case. There's no question. She knew about it when it was in the Court of Appeals in 2016. She probably has copies of all the briefs that were filed in the Court of Appeals.
Mm-hmm.
Kathleen Zellner and her team are aware of every case in the Wisconsin appellate courts or the Wisconsin Supreme Court, especially the Wisconsin Supreme Court,
Mm-hmm.
that deal with post-conviction issues. The number one post-conviction issue, especially in Wisconsin, is Brady. So there are a number of ways attorneys keep up to date on pending cases in the Court of Appeals and the Wisconsin Supreme Court. You get a notice anytime something significant happens by email. You cannot have 19 or 20 exonerations if you are not
Right.
up to the minute,
Right.
up to speed on what's going on. Even though the Court of Appeals decision in 2016 was unpublished, there's no question in my mind that she was aware of it and what the arguments were. Because I've seen some of the things from those briefs in her filings and in this time frame. These cases are not won in the appellate court. They're ultimately won there, but where they're won is how you set up the record and you
Right.
set up the evidence to make your arguments in the appeals court. So the way you set up your evidence is in the trial court. But if you weren't the one that was trying it, you have no control over that. So you try to develop a further record, which she did with her motion for new scientific testing. And then she did it with her motion for post-conviction relief, which you and I are going through step by step.
Right.
But so, yeah, of course it would have been brilliant for her to be, you know, knowing how this was going to turn out and so on and so forth. The really brilliant thing she did is when she got wind that they were looking at the computer again, she followed up on it with her investigators. She had it looked at. She determined that they were holding stuff back. Stuff got deleted. She got the CD, got it to her expert. He found all of those photos on there. He found all of the searches that showed that Bobby could have been impeached with that testimony, which, by the way, makes the withheld information material. So it's got to be withheld. It's got to be exculpatory.
Right.
It's got to be material. And materials either that would have changed the outcome of the trial, or defense counsel could have used it to impeach a witness or show bias.
Right.
And guess what? You got an affidavit from Strang, maybe Buting, saying, if I'd had this stuff, I would have, you know, been able to impeach Bobby. So that is the brilliance of Kathleen Zellner, is that she filed a motion for stay and relief in 2016, the end. They granted it. They sent back the issue on the computer in June. Took them 6 months. So now we got another timeline. Took them 6 months to decide whether they were going to stay and remand that thing. They sent it back. They Judge Angie denied it without a hearing, and she issued her order in August of 2018. And then the brief was originally due in December 17th, 2018, or no, December 20th. And she filed a motion for DNA testing. That was denied. The brief due date was extended to February 1st. And then that's been stayed, put on hold, while this new motion regarding the bones that look pretty much, I don't think there's any question, they were turned over to the Halbach family or turned over to the funeral home, but the law enforcement no longer has those bones. It seems pretty clear. And even the pelvic bones, which apparently, because, and you and I talked about this on December 18th. I don't know if you remember it. We also talked about that they were telling, Fallon was telling Kathleen that they were going to work out a deal where she could test the pelvic bones.
Right.
And you and I brought that up. I said, you know, I don't know what the heck's going to happen if it turns out they've given away these pelvic bones. And, you know, I was asking her in her Q&A and she didn't answer. I understand now why now. But so why didn't you put 8675 in the motion?
Right.
that you just did, but you had 8675 in the testing motion in December, because, you know, she's figuring, well, if Tom Fallon's telling me I can test those bones, surely he wouldn't be telling me I could test them if he knew he gave them away.
Right.
And, you know, attorneys do that. You like to, you develop a rapport, and you realize, you find out, and that's why you have good local counsel also, you know, who can I trust? Who can't you trust? Et cetera, et cetera.
Right.
And, you know, they let her test FL. They let her take that to microtrace, the bullet fragment. And so it looked like, you know, you could rely on those folks. And then when it turned out not to be the case. Well, you all saw her supplement she filed this week.
Right. Exactly. Right. She's yeah, she's basically saying they are basically actively trying to hide things. So
now, those are just a couple of the questions that I saw popping up. I don't know what else you made a note of. If I didn't see your question, I didn't have the chat in front of me. So if I didn't get to a question, if you don't mind repeating it, apologize for you having to do that. But we want to answer all your questions. If somehow it got skipped over, if you wouldn't mind repeating it, we'd love to get to it.
But the changes in this Brady interpretation, will it introduce new Bradys or just make the ones existing easier to get a new trial? Introduce new Bradys. It would apply to any new Bradys moving forward. It would apply to any.
No. So here's why it's so important that she got that computer evidence preserved as Brady. That's now an issue in the appeal. So what she's preserved in her motion for post-conviction relief, plus that computer stuff, that's the Brady stuff. If new Brady stuff comes up 6 months from now, it's not going to be part of the case. She'll have to wait until this appeal's over and then bring another 06 motion, or bring a motion to stay and remand and see what the court wants to do with it.
Okay.
But all of the Brady claims she has made and have perfected, including the computer evidence most recently, all of those will be the subject, you're absolutely right, will be the subject of this new court decision.
Right.
Wayerski. Excuse me.
Is Laura about to start? Okay. Before the end, why are there no motions for BD? Basically, there's no Brady violations attached to Brendan's case right now. They would have to prove that I don't know. They'd have to check and see if their evidence logs show the bones and see if that would apply to them, really, right? And see if the state was holding back on that, and maybe they can make something out of that, right? Wanting to
I just don't
they're not
see
in the
that
current
big of a
appeal, so they could actually do it.
Yeah, I don't see the bones as a Brady violation. I see it as a
the statute, but yeah. But they could do that. They could get Brendan back into court that way.
right under Youngblood and the preservation statute. Absolutely, it applies equally to him. But remember, I don't know how significant those bones were in Brendan's trial. They were at least the pelvic bones were a major issue in the trial of Stephen, and the two positions couldn't be more polar opposite. You know what he said in closing argument. I'm not going to spend more than 20 seconds on those bones. They're not human. And then we know that String and Buting took the position that and got Eisenberg to admit those were possibly human. So, it was a big issue in his trial. I'm not sure how much Brendan's.
Right. All right. So let's see.
Michelle, it looks like they have. Queso says that they were going through the bones for the purposes of separating out the human bones to deliver to the Whiting funeral home, which presumably was to give to the family, and they they were released to Uyghur, and they were never shown as coming back in. And so there's an assumption that Uyghur took him to the Whiting funeral home. We haven't seen any receipt from the funeral home. Kathleen tried to confirm that 8675 was still in their possession, since they were saying that she could microscopically test it last year.
Everybody's asking about Bobby right now. Can he be impeached now? Is there a statute of limitations on when he can be impeached?
Impeaching, I don't think they understand what impeaching is. Impeaching is simply having evidence to confront a witness with that he is being untruthful.
Right.
So, no, I was never at the no-tell motel on Valentine's Day 2019. No, I was never there. Well, how do you explain this receipt with your signature on it at the no-tell motel on February 14th?
Right.
That's impeachment.
And what they're asking is if you come up with that receipt proving that, is there a point where it's too late to come up with that receipt? That's what they're asking.
Well, so here's the thing, and how it relates to Brady. If the state had that receipt and they didn't turn it over to the defense, that's Brady, and it never expires. And now,
okay, never expires. There you go. That's your answer.
but it's got to be material,
right?
So, and that's why it's such a huge thing that Zellner preserved the computer stuff, because
Right.
that is in essence the receipt for Bobby. And you've how did Bobby try to deflect it, and how did Barb try to deflect it? It was in that phone call.
Right.
Yeah, with Stephen. No, I didn't have the internet back then. Yeah, you did. No, I didn't have no internet. Yeah, you did. Well, besides, he wasn't home then. Oh, yeah, he was home. He was looking up all kinds of stuff when you weren't around. And then String has an affidavit in there that I was the one who cross-examined him at trial. I didn't know about this stuff. If I'd have known about this stuff, I would have ripped him a new one.
Martha Dickinson asks, in your professional opinion, Travis, what do you think are the next steps for both sides? And in a new trial or evidentiary hearing, the only way are a new trial or an evidentiary hearing the only way Zellner can get these guys under oath?
Yes, I'll answer that second part first, because appellate courts don't take new evidence. They just hear oral, they just receive written arguments in the form of briefs. If they hold oral arguments, they'll hear the verbal arguments of the lawyers, and then they issue decisions. If facts need to be found or whatnot, it has to be at the lower trial court level, what they call the circuit court in Wisconsin. So, yeah, it's got to go to an evidentiary hearing and then a favorable ruling by Judge Angie or whoever the judge is that it is going to handle it. Right now it's assigned to Judge Angie, and it looks like it's going to stay that way, but you never know. And then ultimately need the Court of Appeals to rule that she's entitled, Stephen's entitled to a new trial. Then whether it'll actually go to a new trial or not, whether the state just says, no, we don't have enough or whatnot, that's a whole different thing. So what are the next steps? And boy, I wish I had this thing that Julie prepared. She had me look it over for changes, and additions, and I had just 2 minor ones. What she did is she got the docket entries from the Wisconsin Court of Appeals and then put an explanation, but essentially for going back for over a year, and really great to be able to track it. But so where we're at now is there's a motion pending, a motion to stay the appeal and remand.
Uh-oh. All right, well, that looks like that may be it, folks. I'm gonna go ahead and wind it down now and cut to Stacy. And that way, those people wanting to go over for Laura's Friday night can head over that way. I think we've kind of talked about this quite a bit, and we can obviously revisit on it as we talk in coming weeks and months here with Travis. So I am going to go ahead and cut to Stacy for now, and
her appeal process. They'll tell her a date to file her brief, or they grant the motion and set forth time frames on when certain things need to be done on trying to get the court to hear the evidentiary hearing. So that's where we're at.
All right. So we're going to go ahead and call it there, folks. Like I was just saying, let those of you who are going to head over to Purple's Friday night, slumber party or pajama party, I forget what it's called, but those of you who are heading over that way can go ahead. I think we've covered this pretty well, but we can obviously cover it again or talk about it again in later videos. Obviously, we're still covering the motion for post-conviction relief, so I'm sure the questions about this will come up as we're talking about issues there as well. So, thank you for being here, Travis. Been a pleasure. And let's see. Let's go with.
Let's see. I have all of the civil cases, Daisy Lady. I will get with you in the other place, and I will get with you on that. I have all the pleadings from the whole Teresa's estate.
All right. Okay.
Tell Dammy coming in the form of a wave, gonna expose another crooked DA. Wrongful convictions, she wears a cape. She's a true life hero, one we should emulate. Always standing up from a very young age. She felt strong enough to defend the weak, the depraved. She's a fighter for justice her whole life long. She does the hard work and then she proves them wrong. Gonna prove them wrong. She gonna prove them wrong. They'll never be coming so soon. Oh, now it won't be long. Oh, yes, we know it's not easy. Even when you got a track record like Queen Z, you gotta dot your I's and cross your T's. You only get one chance to bring them to their knees. You got Bullock and Burroughs, Billy Waddell, you got Devon Jackson too. Saunders and Bradford, Larry and Calvin, the Allen brothers too. You got Kevin it proves them wrong. Don't get strange, no, no, no. Oh, I ain't getting strange. Don't get strange. I ain't getting strange. I'm sick of the suffering.
Which song do you want, Travis?
Don't get strange. Well, we know the story. Oh, wait, the way they say we can see. Later day.
They got to Brendan's head. Totally insane. Don't get strange.
Everything they got. Questionable evidence gathered by
And a wall. But it makes such sense. Why they're in the game. Don't get strange.
Don't get straight, no, no, no. Oh, now I ain't getting straight. Don't
Thank you,
get
Go Mean
straight.
Green.
I ain't getting straight. And that line,
That cheating, that predatory sweaty. Everything he says, you can throw away. He's a legal stain. Don't get strange.
oh, me, we finally find out who's to blame. Don't get straight.
Don't get strange.
So let's keep talking about Avery. Yeah, let's keep talking till he's set free. Oh, you just listen, I think you'll see why it matters. Really matters. Put aside the documentary, the stage version ludicrousy. Oh, all their claims so blatantly get torn to tatters. I think that matters. I bet you heard about Hood Lad Sweat, but maybe you ain't heard this yet. 19 more times the DNA that was left anywhere else that day. I think that matters. I really do. I think it matters. An ex-boyfriend with a day planner page, and yet they did not investigate. And who knows why, and who can say why he was signed into the crime scene that day. I think that matters. I really do. I think it matters. About the barrel that once was seized, but then returned to the Averys. The bones were found the next day, but not one photograph exists of where they lay. I think that matters. I really do. I think it matters. I could go on listing things all 80 more things. I just keep on singing these songs till every freedom rings. I said it matters. It really, I know it matters. It could be you, I think it matters. It could be me, I know it matters.
Well, thank you so much, Selma.
It matters.
You're very kind. Thank you.
I said it matters. It really matters.
We got one more.
Get on the train before it leaves the station. Wisconsin versus Avery, a complete fabrication.
Get on the train
before it leaves town.
The truth train coming, gonna run them down, run them down.
And we all know Stephen and Brendan were blamed, but it does not take a brain surgeon to see that they were framed. Yes, we know what this is about.
The civil suit, the settlement, they did not want to pay out,
And you may hear this song,
or maybe you don't get it. I suggest you look up TikTok, Manitowoc on Reddit.
Get on the train.
Oh my Lord, it just rebooted itself.
Before it leaves the station. Wisconsin versus Avery, a complete fact. And we all know Stephen and Brendan were blamed, but it does not take a brain surgeon to see that they were framed. Yes, we know what this was about. The civil suit settlement they did not want to pay out.
Thank you so much, Joe Green there. Thank you.
And you may hear this song, or maybe you don't get it. I suggest you look up TikTok, Manitowoc on Reddit. You will find
trial transcripts,
evidence files and reports, and you will start to fathom
the corruption within the courts.
Now as you shake your head, because everything seems demented, you will find yourself in company of three unbanked judges that dissented. But don't you worry,
you're not going insane. You just happen to sit down on Zellner's truth train. Get on the train.
I said before it leaves the station, final destination, inevitable exoneration. Get on the train, or before it leaves town, the truth train coming, gonna run them down, run them down. Get on the train.
All right, folks. Love Stacy. Love all of you guys showing up, getting the information, coming here to see, all the new stuff. This is a big one. I think this Brady development here with the Supreme Court there in Wisconsin is a big development. I think it's good. We'll have to watch moving forward. Thank you all for being here. If you haven't already, please hit subscribe, and we'll see you guys. And thank you, everybody, for being here, like I said.